On this morning's docket. Case number 112973, Water District Number 1 of Johnson County, Kansas v. Prairie Center Development, LLC et al.
May I have, may I have 3 minutes for rebuttal, please?
3 minutes is granted.
May it please the court, Lance Kinzer appearing on behalf of the appellates, the Bonhams. I think the framing question, so to speak, in this case is really this. Where a person holds an easement interest over a road, is it possible for a condemning authority to file a petition giving them the right to excavate, to dig up that road for a time without having engaged in a taking with respect to the easement? I think if we start there, some things flow pretty naturally with respect to the way this case has played out to date.
Doesn't that raise a parole evidence question? I mean, how do we know from the petition that they are going to be digging up a road without it?
Because the petition itself grants them the right to excavate over the entirety of the 60-foot parcel that's in question. So I think in this instance,
except that it starts with subject to existing easements. So
it does. And so the question, I think, here becomes, what can the words subject to existing easements of record mean when read in the context of the broader definition of permanent water main easement, if that permanent water main easement at the same time says we can dig up the road? And the argument here that I would make is that that creates an ambiguity. Now, in the context of a contract action, for example, the case law would suggest, well, we have an ambiguity, so then we look to parole evidence to see if we can clarify. But that's not the case law in the context of the Eminent Domain Procedure Act. The Eminent Domain Procedure Act says that even in that context, we don't look to parole evidence. Rather, in the City of Great Bend case would be an example here, we resolve any ambiguity over the nature of the interest to be taken in favor of the landowner. And our most core basic point here is that the language that we are taking subject to easements of record is completely incompatible with the language that says, but we're also going to excavate the road over which you have an easement. The petition says both of these things.
I don't know that they're necessarily mutually exclusive, though, because as a practical reality, you may take, in the petition, you may take a right of excavation, but if that right of excavation is subject to an easement, that pulls it back, and you don't have that right if you haven't condemned the easement.
Well,
they just can't, and if they do, I don't know that the action within the eminent domain.
So the question would be, and what we're contending is that given the description of the interest to be taken on the face of the petition, that this triggered a very minimal obligation on behalf of the condemning authority, and that was to name our parties, my client in the case, and to provide them legal notice.
But the point is, if they come up and tear up your client's road, why don't your clients just sue the water district and say, you didn't condemn our rights, you had no right to do that, and why isn't that action separate? Because the eminent domain is very restricted in the issues involved.
I agree with that, and I think that it is
true. And you're saying that the subject to easement did not give them the right to tear up the road, and why wouldn't that be in a separate lawsuit?
No, we're saying that the petition did in fact give them the right to tear up the road. We don't challenge the fact that the condemning authority, number one, has the authority to decide if they're going to take or if they're not going to take, and number two, they have the right to define the nature of that taking on the face of their petition. What we're claiming is, having done so, as they did in this case, they then have to follow the rules of the Eminent Domain Procedure Act. And that in this case, the way in which they themselves define the nature of their taking creates a taking of the easement that occurred within the context of the Eminent Domain Procedure Act. And that's why we really think that this case is so analogous to the City of Wichita v. Meyer case that we relied upon before the district court even to have the right to appear. It is an odd procedural context. These eminent domain proceedings are not proceedings under the Code of Civil Procedure. They're administrative proceedings. And so,
But that petition in City of Wichita on its face said that the 2 tracts at issue were being taken.
in
This
that
one-
instance,
this one
the
doesn't. This one purports to accept out the easement of your clients.
I would disagree with that in the sense that my reading of the Meyer case, the City of Wichita case, is that initially in the petition itself, the land was not identified and the parties weren't named. There were then some notices in which the land was identified, and then there was a recognition, we've messed this up, in an attempt to amend and have a completely separate second proceeding, but that the parties were never named in the initial proceeding, much like my clients. And so what you wound up with was appraisal number 1 that went through conclusion, in which the parties in that case were not named, and then a second proceeding in which they were named, but the money was never paid into the court, so that was abandoned. And what the court said was that even though you weren't named in the first case, you can still move to void for the procedural problem. In that instance, I think it was clearer to say that the condemning authority, the city, thought they had taken the property because they built an ice rink on top of it after all of this had occurred. But the core similarity is that you have parties who weren't named who were allowed to bring a motion to void for procedural
I'll grant you that
irregularity.
similarity. Let's assume that
Okay.
similarity. But you still had a situation where the condemning authority in the City of Wichita case intended to, and in fact thought it had succeeded in taking the property
And
of the unnamed parties.
And I would
Here
s-
that we have exactly the opposite.
I would say we determine whether the condemning authority intended to take, not by what they say after the fact at a hearing. We determine whether they intended to take based upon the language in the petition.
And can I stop you there and just to ask what I think is the fundamental question? If this court were to interpret the petition in such a way that it does not grant the taking authority the ability to interfere with your client's easement, you would, I presume, or maybe I shouldn't presume, would you then agree that your clients weren't entitled to notice under the statute?
Yes.
And then doesn't the follow-up question then is don't your clients essentially get what they want by different means? I mean, as I understand it, what your clients want is not really notice. Your clients want their easement not to be interfered with. As a substantive matter, that's what they want.
My clients, in all candor, as much as it may seem that at a practical level, the result of if this court were to determine the petition on its face does not take their easement, they still have the ability to bring an inverse condemnation action saying you dug up our road without bringing a condemnation action. My clients really do sincerely believe that they were entitled to, separate and distinct from what happens in damages, the legal right to participate in the eminent domain proceeding as parties and to have the benefits that flow from that in terms of just those procedural rights that they then would have gained. And so,
The risk of participating is that they may actually lose their interest, though. If their ownership rights are actually at stake in a takings proceeding, there is opportunity, but there's also risk, it seems to me. Whereas if this court were to interpret the petition as subject to easements of record, there's no longer any risk, and in fact, I think it would be an unusual circumstance in which the taking authority would sort of ignore this court's interpretation of the petition and go ahead and interfere with your client's easement, wouldn't it?
Well, I would say it's not lost on me that there are potential benefits to my client from a practical standpoint either way that this court chooses to rule on the question that's before it today. I can say in all sincerity that my clients care very deeply about the issue of whether or not they were able to participate in the process as parties, and those legal rights are important to them.
They're purely procedural without any substantive outcome.
To them, the core most important thing is not the monetary issue at the end of the day. The most important thing to them is that they believe their easement rights were taken by the petition as drafted, and that Water One engaged in was mistaken, at putting it in the most favorable terms, to not name them, and that denied them important procedural rights in the condemnation proceeding, which they would have liked the opportunity to vindicate.
And what procedural rights? Because in the condemnation, haven't we said you don't get to litigate necessity, and you don't get to litigate basically anything except value?
From their perspective, this relates primarily to their ability to be at the table as parties when the appraisers are doing their work, to participate on the property when the appraisers are coming out to do their viewing, to have the standing as parties in participating in that process. And whether we view that as important or a big deal, I can simply tell the court that from my client's perspective, they do view those procedural rights as important to them. And it's simply our point that we believe the petition as drafted, we think on its face it does engage because of the right to excavate. The way that the petition is drafted, it talks about all of the 60 feet of the strip of property that's in question. It gives them the right to excavate, not just once, but it gives them the right to return and excavate. And it does that, we think, in a way that makes the subject to language really almost superfluous. But even if the subject to language means something, it means something very much in tension with the other substantive rights that are claimed.
But let's go back to that. You started your argument saying that this creates an ambiguity in the petition, and that we should construe any ambiguity against the taking party. So wouldn't this, I mean, in many ways it seems the simplest result here is if those propositions are correct, if there is an ambiguity, and if we construe it against the taking party, that we simply do that and construe the subject to language as taking priority.
Well, I think it should be construed for the benefit of the party who, and I think in this case the benefit that my clients want me to seek is their right to be named and to be parties and to participate. I certainly understand the point that the court's making. Our view, I guess to try to make sure I'm absolutely clear, we believe that the best, clearest reading of the petition is that it involves a taking of the easement right. We think at worst there's an ambiguity, and that if there is an ambiguity, it should be read in our favor.
And that's because the excavation would impact the roadway.
Yeah,
And that's assuming that it's excavated or the water line is laid from the surface, because your clients only have a surface right. And if you bore through underneath the road for the pipeline, would that still impact their easement if they only have a surface right?
We can say in the matter of reality, I'm trying to stick to what's just in the record, and we didn't get an injunction here, so frankly, the work's been done and the road was dug up. But in terms of what the petition says, the right to excavate is clear on its face. It involves the entire 60 feet of the easement, and that includes Stonecrest Road. And as it happens, the pipe is actually laid directly below Stonecrest Road, just as a matter of the way things really played out. The Bonhams have had this easement right since the mid-1960s. They purchased this property along with 4 other friends who wanted to buy it. They didn't have enough money for each of them to be able to purchase, so they divided it up, each built a home there. Mr. Reed, who owned the original property, had some property to the north, and he ran cattle on that property. He was concerned about access, so instead of what would probably have made sense for him to take an easement, he wanted to hold the fee, and the Bonhams and the Wheelers basically built the road, and it was maintained for 50 years. They've used it every day as their way to get down to Dennis Avenue to get in and out of their home. And so, and I think that the trial court even found that, as a finding of fact, that hasn't been disputed, that the road was going to be dug up as a matter of reality. So.
And you said that did in fact happen?
Yes.
And was your client's easement interfered with during that time, or were there accommodations made?
And this gets to a second point. As a matter of reality, their easement interest, their ability to gain ingress and egress over that 60-foot parcel they were not able to gain ingress and egress in that fashion. Water One, this I think is all outside the record now, but to answer your question, Water One had acquired additional property to the north, and there was a means that wasn't available before when the construction wasn't going on and isn't available now that the construction is concluded, where they could wind their way through to another access point to the north. So they were not landlocked by what occurred, but they were completely denied the ability to gain access to Dennis Avenue over their easement.
Okay. Any further questions? Thank you, counsel.
Thank you.
And may it please the court, I'm Paul Shepard, York and Erskine firm, here representing the Appalachia Water District Number 1 of Johnson County. Let me begin by stating as emphatically as I can, Water One had no intention of acquiring any property interests from the appellants in this case in connection with the
So you deny that you tore up their road?
Pardon me?
You deny that Water One tore up their road?
Well, I'm a little uncomfortable with that whole line of questioning, Your Honor, because it goes completely out of the record. We deny
there was no intention on the part of Water One to excavate over the easement?
There was certainly no intention on the part of Water One to acquire any interests from the appellants that would enable them to take any of their access rights.
Excuse me, Counselor. If you stop the easement holder from traveling over the road, have you not taken part of that interest from them, even if it's one day?
We do not believe that occurred, and to the extent that any rights were interfered with by Water One in the course of this project, then the appellants have every right to go to court and file an inverse condemnation claim seeking to be recompensed or awarded damages for the acquisition of those rights. What we're here to talk about is the rights that Water One sought to acquire in the eminent domain petition that was filed in this case. Water One had no intention of taking any rights from the appellants. Water One drafted their petition to clearly state that the interests they were acquiring in the course of that proceeding were subject to all easements of record. If there's anything ambiguous about it, it's not a situation where Water One made a conscious decision to take property interests from the defendant and then purposely refused to failed to name them in a case that is anywhere similar to the city of Wichita versus Meyer. And again, you have to remember that the conveyance instrument in an eminent domain proceeding is the appraiser's report. In the city of Wichita versus Meyer is what happened, and I believe counsel for the appellants is fairly accurate in his description of that. The eminent domain petition made no mention of two tracts that the city of Wichita sought to acquire. I believe it was tracts 46 and 47. The owner of that tract was not named in the eminent domain petition. But when the appraiser's report came down, it awarded title to the city of Wichita to those 2 tracts, which were not referenced in the eminent domain petition.
Well,
That-
along those lines, counsel, let me just ask you to set aside, if for a minute, the petition that was filed in this case, and just ask a very basic question about the statutes. If a taking authority is going to tear up a road over which a party owns an easement, is that easement owning party entitled to notice under the statute?
Only if the eminent domain petition seeks to acquire those interests. And it's up to, it is well within the discretion of Water One here, and the case law is very clear on that, to determine the nature of the interest it needs to acquire in order to complete a project.
And
if
I'm-
they make a mistake, I'm sorry, I didn't mean to interrupt. I apologize to Justice Johnson for my previous interruption, but go ahead.
Well, I guess what I'm trying to do is ask about what you said you're uncomfortable talking about, which is the realities of these situations. I understand there may be circumstances where a taking party, might make an error, might engage in activity that they didn't know was outside the scope of the petition. But set that aside. If the intent of the taking party is to dig up a road over which a party has an easement, does the easement owner have a right to notice under the statute? That's my question, really simply.
Only to the extent that that right is going to be taken by the appraiser's report that's filed in the eminent domain proceeding,
Permanently taken, is that your position?
taken in any respect.
Well, I was gathering from these comments that there's a suggestion there is a temporary taking for as long as that easement is torn up, until it's restored.
I was responding to the question as to whether or not a eminent domain petition could be voided because of a mistake that the condemning authority might make about the impacts of the performance of a project on interests of holders of property interests is not named in the petition.
Counsel, I think if I can come back to my question, you're getting down in the procedural weeds a bit more than my question asks. What I'm really asking about, I think, is legislative intent. And I want to understand from your perspective what you think the intent of that notice statute is.
The intent of the notice statute is to provide notice to property owners whose rights are going to be affected by the appraiser's report that's filed in
So
the
you
case.
think it's the statute's intent is hinged on the report. It's not hinged on the actual interference with their ownership.
No, it's not hinged on actual interference. If you read KSA 26504, that outlines the procedures that are employed by a district court when they're presented with an eminent domain petition. There isn't any evidence presented at a proceeding of that nature. All that the district court does, as dictated and directed by 26504, is to determine from the petition itself 2 things. Does the condemning authority have the power of eminent domain, and are the property interests which the condemning authority seeks to acquire, as alleged in the petition, necessary to complete a project? You don't get to come in and bring in evidence about whether or not that was a good decision, a bad decision, whether or not this property is necessary or that property is necessary. All those determinations are made from the face of the petition. There's nothing in 26504 that allows any party, whether named or otherwise, to come in and say, Judge, I want you to hear some evidence about what we believe the impacts of this project are going to be, and I believe the impact of this project is going to be to, in some way, infringe upon my rights, and I'm not named in the petition, so I'm entitled to.
And if there is an ambiguity in a petition, how should courts deal with that ambiguity? I mean, I can think of one way, certainly, and this is the way that the petitioners seek to have the ambiguity construed in such a way that notice is given as widely as possible. If there's an ambiguity, then you say, we'll construe the ambiguity or we'll construe the language to include as wide a net of potential property owners as possible.
I think you're talking about amendments to the Eminent Domain Procedure Act, which is the purview of the legislature. And what
No, I'm just
what-
asking about if there's an ambiguity in the petition. You said the rights are determined on the face of the petition, but if there's an ambiguity, what happens next? With regard to notice specifically.
The only ambiguity which would have any bearing on the defendants that need to be named in an eminent domain petition is whether or not the petition itself, and which will lead to the appraiser's report, whether there's any ambiguity in the petition itself with respect to interests that are going to be acquired
Correct.
in the eminent domain proceeding.
I understand that, and the Bonhams are alleging that the petition itself was ambiguous because one reasonable interpretation of it is that their interests were going to be condemned. That's, as I understand it, that's their argument, and they're saying because that's an ambiguity, we should have gotten notice.
If that's our argument, it's baseless, because there's nothing ambiguous.
So your argument is that it's not ambiguous.
It's not ambiguous with respect to whose interests are going to be acquired in the eminent domain proceeding. Now, whether it's ambiguous as to whose interests might be affected in the course of the performance of the project is another question altogether. But that's a question to be resolved in an inverse condemnation proceeding down the road. And there is no procedure in the Eminent Domain Procedure Act which would permit someone to come in and say, you know, I really think that the project that's going to be undertaken in connection with this eminent domain petition is going to hurt me. And therefore, I need to be named as a party. Challenges to the exercise of eminent domain are, except in one instance that I'm aware of, they all involve situations where defendant owners who've been named in an eminent domain petition complain that the condemning authority has overreached, that the condemning authority is undertaking a project which they don't have the power to condemn in connection with. The only case that I'm aware of in which any party to an eminent domain petition ever came in and said, wait a minute, my interests are going to be taken in this proceeding, and therefore I need to be able to participate in an appraiser's hearing, and the eminent domain petition should be amended in some way to allow me to participate. And that's the State Highway Commission versus Bullard case. And as I believe you're aware, in that case, there was a petition filed, eminent domain petition, seeking to acquire fee simple interest in a particular parcel of property that was subject to a lease. Both the fee owner and the lessee were named as parties in the eminent domain petition. And then the condemning authority went ahead and made a deal and purchased the property from the fee owner, and then was going to dismiss the eminent domain proceeding. And the lessor in this case was a much stronger argument than the appellants have here, because in that case, it was clear on the face of the eminent domain petition that the leasehold interest was being condemned and taken as a result of that proceeding. And the court said, no, if they want to go forward with the project, the Kansas State Highway Commission is allowed to do that. You can't force them to engage in an eminent domain appraisal process with you if they don't want to do it. Your remedy, to the extent you think that the performance of this project by the condemning authority is going to damage your property interest, your remedy is not to force that through as a condemnation proceeding. Your remedy is an inverse condemnation. And we do not believe, as we sit here today, as long as we're going outside the record, that we took any interest or we disturbed the interests or damaged the interests of the appellants in this case in the performance of our project. And
But
we
that-
stand ready,
but your
willing, and
view-
able to defend an inverse
Excuse me,
condemnation
counsel,
petition.
but your view is that that's an issue for another day in an inverse condemnation proceeding.
Absolutely. There
And
is
that,
no
as
provision
long
of
as
the
we're
EDPA
outside
that, pardon me,
As long as we're outside the record, there is no such proceeding on file.
that's up to the appellants to file.
There is none on file
No.
today.
No. And a project's complete.
And let me make sure that I understand that your answer is the same, even if we find an ambiguity in the petition? Or
My
does that
answer
change
to
it?
the ambiguity question is, first of all, it's not ambiguous
I
at all.
understand, but
It
I'm
says
just asking-
subject to the easements.
I'm just asking you to assume we would find an ambiguity. I want to know what your responses, then what happens? How we should interpret that? Back to Justice Stiegel's question, do we give notice to a broader group that might be affected as we would interpret the ambiguity?
No, you don't give notice to anyone other than the condemning authority names as holders of interest that they seek to obtain in the context of the Eminent Domain Procedure Act. To the extent someone else says, I'm looking at this petition and I think it's going to hurt me, that person's remedies an inverse condemnation, not by trying to force the condemning authority to include an amendment to the eminent domain petition that seeks to acquire some interest when the condemning authority doesn't think it needs to.
I think our disconnect is you're not willing to move into the hypothetical with me. Because
I'll
what
try.
I'm asking you to assume is that we have found an ambiguity. That ambiguity indicates that you are going to impede upon the property rights of someone. What happens then?
To the extent that property rights under your hypothetical, as I understand it, are impaired or infringed or taken in some part, that's not going to occur as a result of the processing of the eminent domain petition. If there were an ambiguity, perhaps, in the appraiser's report, that's what happens in a Myers situation, although there really wasn't any ambiguity there. When an appraiser's report comes down and gives the condemning authority rights which are not claimed in the eminent domain petition,
Well, or it incorporates the same language that has the ambiguity, which it probably will. It'll probably copy that description almost word for word.
to the extent there's any ambiguity with respect to the rights that the Water One might have acquired through that appraiser's report, I'm here to state on the record, as we did in the district court, those rights don't include in any way, shape, or form any right to infringe upon the appellant's easement rights. We've conceded that. That's not an issue. We're not going to claim in defense of an inverse condemnation claim that we've acquired any rights from the appellants with respect to their easement. So, again, but you're talking about an analysis of the petition and potentially the introduction of parole evidence to explain an ambiguity, and then forcing a condemning authority to disregard its own discretion and name additional defendants in a petition. And there is absolutely nothing in the Eminent Domain Procedure Act that contemplates such a thing or contemplates such a process. The basic fundamental principle that we have here is the condemning authority has complete discretion to determine what it's going to take. When it drafts the eminent domain petition, the sole role of the district court is to determine whether the petition alleges that the condemning authority has the power to do this and that it's necessary to complete a public works project. And there isn't anything else that is contemplated to be done in that context. To the extent that a property owner claims that there's been some kind of an abuse of discretion or fraud or bad faith on the part of the condemning authority, then there's a procedural remedy for that, and that is to seek an injunction. But it can't be done in the way that it was done in this case. You can't go into the eminent domain procedure, eminent domain proceeding, and try to say there's something wrong with this petition. That has to be done in a separate action. And I know that wasn't one of the grounds on which the district court relied on to deny the appellant's motion, but this court has the power and I think a duty to affirm the district court if it's right for any reason. And one reason that the district court was right is that to the extent there was any arguments that were to be made by the appellant in this case, that had to be done in some other proceeding and not in this eminent domain proceeding.
Just as a clarification, you could have clearly set forth in the petition that we intend to take this easement,
Absolutely.
and the appraisers therefore would have been tasked with the responsibility of determining the damages
No question.
to the bottoms.
No question.
All right.
And then the appraiser's report would have a provision in there that instead of being subject to the Bonham's easement, we took interests from the Bonham easement that allowed us to do things. But again, I'm a little uncomfortable trying to argue that the Bonham's rights were not affected here, because that's not really in the record, although I've been told in no uncertain terms that that did not occur. And again, we stand ready, willing, and able to defend an inverse condemnation claim that challenges otherwise.
The bottom line here is that if the condemning authority is mistaken in what it's taking, or intentionally decides to take something that it doesn't want to disclose in the petition, or any defect in the petition, the remedy is to go sue them in another proceeding, not to try to play in the condemnation action. Isn't that right?
I think that is as well established as any principle in eminent domain jurisprudence, Your Honor. And then to the extent a project or the implementation or performance of a project might cause damage, as was the case in the Kirkpatrick case, then the remedy is an inverse condemnation.
Any further questions? Thank you, counsel.
And Justice Johnson, I apologize again for interrupting. I get a little carried away. I know I've got an audience of these young kids from Kansas State. I maybe got carried away.
You reserve 3 minutes for rebuttal.
Yes, sir.
Mr. Kinzer, to Justice Biles' point, and that's, when I read the briefs, I've been quiet in this because this just seems to me, this is an inverse condemnation claim that your client should have made or you should have made. Why am I wrong on that?
You're not wrong that my clients have inverse condemnation as a potential remedy. I think where you're incorrect, and what I think the city of Wichita v. Meyer case shows, is that we also had another potential remedy, which is the one that we chose to exercise, and that was to move to void the proceedings based upon the specific facts of this case. Now, the ability to move to void only arises in a relatively narrow set of factual circumstances, but it is recognized, and we think this fits precisely the kind of circumstances where a motion to void is appropriate. My concern with the argument that the condemning authority is making here is that, let's imagine my client doesn't have a mere easement interest. Let's imagine my client has a fee interest and they want to take a temporary construction easement, which often happens in these cases, over the fee. And they just draft their petition to say, we're taking parcel 1 subject to all fee interest, and then they define it so that they're going to have a temporary construction easement. They don't name the fee owner. And then the fee owner says, well, you've got to name me. You're coming onto my property. You've got a eminent domain petition you filed that describes my property. And they said, but no, we're taking this easement subject to your fee interest, so we don't have to name you or provide you notice. That is abusive, quite frankly. And when the condemning authority says that we can describe our interest however we want, and then just tack the words subject to on the front of the definition, and we can force you then to become plaintiffs in a inverse condemnation action instead of getting the procedural rights that are defined for you by statute, that is problematic. So I agree with the court that we have a right to bring an inverse condemnation action, and depending upon the judgment of this court, that may be where things ultimately wind up. But that remedy in this case is not an exclusive remedy. We also have the right to move to void in this context where a petition, not like the Bullard case. In the Bullard case, there was an abandonment of the action that was taken. And so the parties in that case were saying, hey, there's no condemnation action at all, but we basically want to force you to start one. In this instance, there is a active, ongoing condemnation action that identifies the parcel of property that my clients have an ownership interest in. We would argue that it identifies a taking of their easement interest. We think on its face it does that. At the very least, it creates an ambiguity as to whether that easement interest was going to be taken. Since we are going a little bit beyond the record, I mean, I was at the property while the bulldozers were out there digging up the street. I mean, there's no question, the road was excavated and was impassable. And I'm sorry.
And they were
no
given
question.
an alternate route into their property.
Yes, yes.
Let me just see if I understand. You're saying, yes, we have this other remedy, but it's incomplete for what we've been denied. That's
Yes.
in essence what you're saying. It's incomplete. It can get us compensation for the use of our property during the time it was torn up and the fact that we had to drive around and those inconveniences that are associated with it. But it's not compensating us for the fact that we had to become plaintiffs, that we had to take the lead, that we had to file a lawsuit, that we had to forego all of those procedural protections that are coming to an owner under the eminent domain procedure.
That's exactly correct, and I think that last point, the foregoing of the procedural rights that are statutorily established for owners whose interests are taken, is the one that my clients are most concerned about and don't believe is fully vindicated in an inverse condemnation action.
Okay, thank you.
Any further questions?
What happens if we void the proceeding?
If the proceeding is voided, I believe that it creates a little bit of an interesting question, but I think that all that really occurs is that Water One initiates a new proceeding in which we are named as parties and provided notice. The other parties who were at least the subject to the condemnation are noticed up as well. A new panel is appointed, and a determination of value is made. I don't prejudge what that will be, and then there's a process, a statutory process for determining any division of award among those who have an interest in the property. And so I think that's, in essence, what would occur.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement